I welcome everyone here today. And welcome representatives from the Law Council of Australia. We've received your submission as submission number 34. Do you wish to make any amendments or alterations to your submission?
No, thank you.
So for the Hansard record, would you please each state your full name and the capacity in which you appear today?
My name is Phillip Richard Boulten. I'm a member of the National Criminal Law Committee at the Law Council of Australia.
Welcome and good morning.
Thank you.
Sarah Moulds. I'm the Acting Co-Director of the Criminal Law and Human Rights Division at the Law Council of Australia.
Natasha Mould. I'm a policy lawyer in the Criminal Law and Human Rights Division of the Law Council of Australia.
Great. Welcome all. Do you wish to make a brief opening statement and then we'll take you to questions?
Yes, I'll make the statement for the Law Council. We welcome the opportunity to appear this morning as part of this important inquiry into the TIA Act. I'm a member of the Law Council's National Criminal Law Committee, and you're probably well aware that the Law Council is the peak national body representing the legal profession in Australia. It has specialist committees made up of representatives from the law societies and the bar associations around Australia with experience and expertise in certain areas. And the Criminal Law Committee is one of those committees. We have a strong interest in the current inquiry, and we've contributed to the Law Council's detailed written submission, which you have. So have other Law Council committees, including the Business Law Section's Media and Communications Committee and the Privacy Committee. The Law Council has also had the benefit of an opportunity to meet with ASIO, including the Director General of ASIO. These meetings have provided good insight into the practical operation of some of the internal processes and procedures that apply to ASIO's use of its powers under the TIA Act, including processes to ensure organisational separation in terms of operations and warrant compliance, as well as the potential for the Inspector General of Intelligence and Security to act independently to initiate inspections to monitor ASIO's applications for warrants. Following these meetings, the Law Council provided a supplementary submission to the committee, which encourages the committee to carefully consider the appropriateness of a statutory prescription of ASIO's internal processes and guidance which relate to observing the principle of proportionality as a necessary safeguard against which ASIO compliance can be assessed. By way of opening statement, I want to express the Law Council's support for a comprehensive revision of the TIA Act. The Law Council supports a review which considers how the TIA Act can continue to respond effectively to issues of national security and law enforcement, while at the same time acknowledging the underlying principle in Section 7 of the Act that telecommunications should not be intercepted. As the Attorney-General has noted in a recent speech to the Centre for Strategic and International Studies in the United States, the challenge is to ensure that Australia's interception and access regime continues to respond to emerging threats to national security, but does so with the smallest necessary encroachment on individual rights. The Law Council recognises that Australian law enforcement and intelligence agencies confront operational challenges as a result of rapid changes in telecommunications technology and in terms of the way this technology is used in the community. It's clear that the types of devices and services we use to communicate and the frequency and volume of those communications have changed dramatically since the first legislation on telecommunications interception powers was introduced. It is also clear that the way ASIO and other intelligence agencies go about collecting intelligence on matters relevant to national security has changed. Notwithstanding this, it should also be emphasised that Australian law enforcement and intelligence agencies have requested enhanced powers many times in recent years on the basis of the need to respond to those challenges. In many cases, these requests have been granted, generally with varying levels of safeguards and accountability provisions. As a result of the current legislative regime, there is a vast array of powers available to law enforcement and intelligence agencies to intercept and access telecommunications and to disclose telecommunications data. Similarly, the ASIO Act contains a set of special powers that have been continually expanded in the last decade to include personal and property searches, computer searches, and the covert use of listening and tracking devices. It's against this background that a comprehensive review of the TIA Act and any proposed reforms should be assessed. Unless each of the proposed reforms can be shown to be necessary and proportionate in light of threats to national security, they should be rejected. This is particularly important in the context of a regime that can have an intrusive impact on the rights of people who themselves are not suspected of criminal activity or are of national security interest. In the context of telecommunications access and interception, this demands a warrant process that carefully considers the intrusiveness of the interference with the right to privacy, as well as whether the information sought could reasonably be obtained by other less intrusive means. It also demands a level of oversight that allows the community to be confident that these powers are only being used in accordance with the law. The Law Council has previously raised concerns that the current warrant and authorisation processes in the TIA Act fall short of these requirements and has suggested improvements, such as the inclusion of a single, consistent privacy test in all warrant applications and in all authorisations to intercept, access or disclose telecommunications or telecommunications data. The Law Council has raised these concerns in submissions to the inquiries that are included in the terms of reference for the current inquiry. It also raised concerns with past proposals to extend the powers in the TIA Act or otherwise dilute or remove safeguards such as those proposals subject to consideration by the Parliamentary Joint Committee on Intelligence and Security in 2012. These are outlined in detail in our written submission. In raising these concerns, the Law Council doesn't wish to oppose reforms that aim to improve efficiency or the effectiveness of the TIA Act at meeting its legislative objectives. The Law Council considers that concrete proposals for reform that seek coherence, consistency and uniformity across Australian jurisdictions in the area of surveillance regulation, including the telecommunications interception and access area, is needed and desirable. To this end, the Law Council supports several recommendations made by the Australian Law Reform Commission and the Parliamentary Joint Committee on Intelligence and Security relating to, for instance, the need for a review of reporting requirements, oversight arrangements, the threshold for access to telecommunications data and information sharing provisions. The Law Council is also of the view that certain critical reforms of the TIA Act are urgently needed and should not be dependent upon the completion of a broader review process. In particular, the Law Council considers that there's a need for immediate legislative amendments to the TIA Act to, 1, introduce defined limits on the issue of B-party warrants that can target people who are themselves not suspected of criminal wrongdoing or considered to be of national security interest, and the derivative use of material collected by a B-party warrant. Secondly, amend the threshold for access to telecommunications data with a view to reducing the number of agencies able to access such data. Thirdly, increase the penalty thresholds for stored communications warrants to apply only to criminal offences. And fourthly, to increase the threshold for sharing stored communications to that prescribed in sections 110 and 139 of the TIA Act.
Mr. Boulten,
Thank you.
Oh, okay. I was just going to wind you up, but...
That's fine, thanks.
All right, very much appreciated. Senator Marshall, do you want to kick off?
Yes, I'd just like to ask if you would expand on your views about the introduction or the potential introduction of mandatory data retention regime.
There's great grave concern in the legal profession about that proposal. We've not reached a final consensus amongst our members about it, and we probably will not be in a position to be able to say anything definitive until we actually see a firm proposal. But there are grave concerns that holding that sort of data for, say, 2 years is going to seriously jeopardise privacy considerations and will lead to extraordinary costs for internet service providers. I note with interest the decision of the Court of Justice of the European Union this month that struck down the Data Retention Directive, and did so really because of the sort of concerns that exist in the legal profession here in Australia. The directive there would be similar to a law here that would require data to be kept for perhaps 2 years. There, one of the reasons the directive was struck down was because there was no real differentiation between what sort of data was to be kept. Data that was entirely innocent needed to be kept along with data that might be likely to impact on national security issues or serious crime investigation issues. There was a problem about the length of time that data was to be kept. The proposal in each case considered by the court there was a 6-month proposal. And the risk of abuse that was inherent in that scheme seemed to be at the heart of the decision. Interestingly, one of the reasons the court struck it down was the fact that the data might not be held within the European Union itself. This poses real concerns for our consideration here in Australia. If internet service providers are maintaining their data in clouds or in data banks that are outside our jurisdiction, it rather tends to leave a whole lot of questions unanswered. How can we enforce it? If the data is being held in circumstances where it can't be kept completely securely, the data can be accessed perhaps improperly by organisations well and truly outside Australia's control. These questions have not been really answered.
Thanks very much, Senator Marshall. Along those lines, I put that similar question yesterday, I think to the ACC, to the gentleman who was representing them, and they said, well, the key difference between Australia and Europe is that we have privacy protections that mean that that ruling in Europe wouldn't be strictly relevant to the Australian context. But they didn't offer any more detail than that. Are there protections that you're aware of here in Australia which would offset some of the reasoning that you've just described that was assumed in Europe?
Not quite yet, there isn't. We do have the Privacy Act and privacy principles. We are urging that the TIA Act contain a uniform privacy provision that requires those sorts of privacy considerations to be given full and consistent regard at all stages of the process of obtaining and executing TIA warrants. But unlike Europe, Australia does not have a human rights bill, nor do we have a court like the the Court of Justice of the European Union, which has regard to those human rights norms. So we don't have the same sort of judicial oversight for our legislation that European Union members have. And if anything, Australian legislation is going to be much more prone to privacy abuse than legislation in Europe.
So As a result of submissions made already so far to this committee, there is more detail now available as to what law enforcement agencies are seeking in terms of data retention. So I wonder if the Law Council does come to a view while this inquiry is afoot, if there's anything else that you'd like to provide us with once you've had time to assess the submissions that have been made to us. Would greatly appreciate it. Just one more question from me and then I'll throw to Senator Seselja. You're quite critical of the proposals for attribute-based interception. Do you want to can we maybe tease out your view on that, because it's another fairly strong push that's coming from the AGD and the various law enforcement agencies yesterday?
Yeah, well, the Law Council actually opposes a single interception warrant regime or attribute-based warrants because at the moment there just doesn't seem to be enough certainty about what will actually be scooped up by all of this. The problem with the imposition of a single warrant process is that there can be a very great dilution of specific safeguards. In particular, without knowing the details of each device that's sought to be intercepted, there is a real risk that just a complete plethora of devices will be scooped up, including devices that are used ordinarily by people who are not persons of interest or suspects, and that there would be a disproportionate usage for the need of the agency. We would require really stringent safeguards if there was to be such a mechanism. In particular, the legislation ought to spell out that the person granting the warrant would need to have regard to the privacy concerns of all people who might be going to be or might likely be using such devices, not just the privacy concerns of the target of the operation.
Thank you very much. I'll come back later if there's time. But Senator Seselja?
Yeah, thank you. Mr. Boulten, just a couple of follow-up questions. I think the additional information that we've been given, which I think you read into Hansard, forgive me if I've misunderstood that, but you talk about having a regime where the Inspector General would have oversight prior to a warrant being issued. Are you able to just maybe give us some more insight into the rationale for that? Is it that you believe that the warrant system at the moment is not working effectively? Is there significant evidence for that? And is it a situation where those granting the warrants aren't, granting them in a legally correct way? Is that the reason why you would want that kind of oversight happening prior to the issuing of warrants?
If I can just step back and talk more generally, not just about ASIO warrants, we are of the view that some independent person would benefit the process if they became engaged prior to the issue of the warrants.
Just to cut you off there, though, is the issuer of the warrant not independent?
The issuer of the warrant is, yet it seems that almost every warrant application that is made is successful. We're of the view that a public interest monitor for general warrants and the Inspector General's involvement for ASIO warrant would just give that extra degree of oversight that would focus the applicant's attention on privacy issues and the interests of others that are not necessarily the targets of the investigation, in order to make sure that there is that careful consideration given to a step which will, in many respects, undermine the privacy of not just the target, but of others as well. We understand that the Inspector General does from time to time play such a role and is entitled to play such a role now in ASIO warrants. We would think that so long as there were no resource issue and that they were adequately funded to do the job, that should be a matter of course.
Okay. On the public interest monitor that you raised Law Council's obviously in support of that. We've also had other submitters who have expressed their opposition to the establishment of the public interest monitor at a national level, and they basically argue that the functions a PIM would carry out are already provided for. Did you want to respond to those concerns? Those concerns have been raised, I think, in the AFP submission, in Independent Commission Against Corruption South Australia's submission, the Northern Territory Police and the Corruption and Crime Commission of Western Australia all raised broadly those concerns.
Yeah, look, the person who issues the warrant, although not acting judicially, acts as if they are a judicial officer. They're not there with a view to testing the propositions necessarily. They're not an active tester of proposals. If the application fits all of the statutory criteria, they must grant the warrant, otherwise they're not acting in accordance with law. The public interest monitor would play an active role in just literally testing the propositions that are being sought to be advanced by the applicants. It is interesting that the opponents of public interest monitors in their submissions all seem to be made by people who would normally be making applications for warrants. I'm not saying that there's no substance in their argument. There clearly is a view that they shouldn't be hampered in their job of seeking these warrants. But a public interest monitor, which is in operation in Victoria, for instance, would just give that extra degree of resolve to the applicants to make sure that their application not only addresses their operational objectives, but also gives more than lip service to the privacy considerations that in the heat of the moment of an investigation might be overlooked by active and aggressive investigators.
Okay. You mentioned, I think, in one of your answers that one of the things we need to look at was the number of agencies able to access data. And we heard a little bit of that yesterday as well, that some of the concerns raised by some of the agencies were the ability to share data and also, I guess, whether or not the extent of the agencies that can have access to data or can actually access data under the Act is appropriate. Do you have a view as to what type of agency that should actually extend to?
Yeah, especially for prospective data, that should be shared amongst people who have a legitimate right to it, in the sense that they would be able to make an application for a similar warrant, and they are going to use it for the same statutory purposes as the person who actually obtained the warrant in the first place. There's a real risk at the moment for historical data to be shared with people who are getting access to material that was first obtained to investigate serious criminal activity or national security issues, but who then use it for purposes that bear no or little resemblance to those important objectives. So our criteria essentially are, one, you should only get it if you're investigating serious crime or national security issue. and 2, you should use it only for that purpose.
So you would, sorry, Chair. So you would, because I guess you're on the same page in one sense with some of the evidence we heard yesterday in terms of perhaps the type of agencies that might be able to access data, but the other one of the frustrations that was shared by I think the Crime Commission and others was the ability to share relevant information with other Commonwealth and other agencies that was of a law enforcement nature. Do you have any sympathy for that position, their ability to share where they do uncover breaches of legislation which is administered, for instance, by other agencies? Do you have any sympathy for that position, that should be able to be shared amongst law enforcement agencies at the very least?
Yeah, but in a way that doesn't dilute the original application. If a Commonwealth law enforcement agency legitimately investigating a very serious set of crimes, comes across information that suggests that someone hasn't paid their tax last year, the tax office wouldn't have been able to get the warrant in the first place. So why should they be given the information in those circumstances? The criteria should be tightly applied so as to ensure that the information doesn't get out, doesn't leak to organisations or persons that wouldn't have been able to get it in the first place in the initial warrant.
Thank you. Thanks, Senator Seselja. We've got time for one last quick question from Senator Xenophon.
Mr Boulten, Nick Xenophon here. I just wanted to, I've got a particular interest in metadata surveillance and the use of warrants in Section 70 and 79 of the Crimes Act matters, effectively whistleblower investigations, and in particular whether members of Parliament are subject to such surveillance in that context. And the Federal Police Commissioner has acknowledged as such in Senate estimates. What I'm concerned about is, do you think there should be a different threshold when it comes to members of the public service approaching a member of Parliament which otherwise would be the subject of a Section 70 or Section 79 Crimes Act matter, whether there should be a higher threshold for either metadata surveillance or for telecommunication intercept in such cases?
Well, I've got to say, Senator, I'm not fully equipped to answer your question right at the moment. I'm not sure what the maximum penalty is for Section 70, but or 79. But it does seem to me that if a public servant has committed a criminal offence that carries the maximum penalty that would tip the offence into the definition of serious crime, there's not much that can be done about it, I wouldn't have thought. There would need to be a special exception made for public servants that perhaps wouldn't otherwise apply. And I suppose the best people who are in a position to make a judgment about the importance of that issue are you and your colleagues, Senator.
So you don't think that if a public servant is going to a Member of Parliament with essentially to blow the whistle on maladministration, malfeasance, whatever, you don't think there ought to be a higher threshold for telephone or for telecommunications interception?
Well, that would depend very much on the view of Parliament about the seriousness of that crime. Of course, there would be many instances where ordinary people in the community would regard such a person as being a hero, but that's not a universal view. And whilst ever Section 70 and Section 79 continue to be a criminal offence, there's going to be real issues in determining how to weed it out from the TIA Act.
Thank you.
All right, we'll leave it there. Thanks very much for your time, for all three of you for coming in this morning, and we will call forward the Australian Commission for Law Enforcement Integrity. Thanks to the Law Council.
Pleasure, thank you.